everyone. Welcome to our fourth webinar in the ongoing series. I'll be the moderator today. I am Gaurav Goyal. The host for today, the speaker for today is Jean-Christophe, who's a dear friend of mine. He's a commercial mediator and a co-president of the Swiss Chamber of Commercial Mediation. I met him at the ICC 15th International Commercial Mediation Competition. He was a judge and a professional there, and I was coaching a team from Jindal Global Law School. Jean-Christophe has 2 executive MBAs and 2 law degrees. He was an in-house counsel for a couple of years before he moved to a full-time mediation. He's also a trained negotiator, and his business or his commercial aspects span over multiple continents. He is active in Brazil, he's there in Switzerland, he's in Germany, he's in France, he's in Austria, Dominion Republic, you name it. He was in India in the end of February. And we had thought of organizing a small seminar with him, like a proper accreditation course sometime in September, along with other trainers that we have that will be doing some of the webinars with us. However, thanks to COVID, all those plans have been shelved, at least for this calendar year. So nevertheless, JC has agreed to do a few webinars with us. So this is many of the first. So today's topic is how to develop career in commercial mediation. First of all, I would just request everyone to switch on the videos. We'll keep an interactive session today. You'll be on mute for most of the session, but we will open up the mics towards the end of it if we want to permit someone to ask questions directly. So that's about it. If everyone can start the videos, and yes, please pin JCB. You would see from the participant list, you would see JCB. So just pin his video to your screen so that you'll only see him. Small introduction about me. I am a young practitioner. I practice mostly in the commercial laws, construction law, a lot of white collar crimes also. I'm a trained negotiator and a certified mediation advocate. I am also a member with the Chartered Institute of Arbitrators. I did my master's from UC Berkeley back in 2016 in international commercial law, international commercial arbitration, tax, and international legal research. I did my bachelor's in India in 2013, and I've been practicing ever since. So yes, I can see a few videos on the right, requesting everyone else to start the videos if you can. And we'll just start with the session. It will be a 1-hour session, and we'll keep the Q&A towards the end for about 15-20 minutes. Let me see if Jean-Christophe is right there. Oh, and before we start, I would love to know why mediation, what is the interest in mediation? If anyone would like to speak, we'll unmute them. How about, okay, so Akshat is there. He's a trained mediator. Maybe he can share something about it. Akshat, would you like to speak?
Yeah, so as you said, as you correctly said, I'm a trained mediator. I'm also involved in generally coaching a lot of teams which go for competitions, etc. The reason that I've joined the session today is not just to sort of get an introduction to mediation, but how to really build a career in mediation is stuff that a lot of people, especially law schools, don't really teach teach students. They don't really tell you how to, or not just law schools, like even law practitioners, etc. They don't really take mediation very seriously as a method of dispute resolution, and as such, making a career in India largely focused on mediation is not something that's been super successful so far. So just to hopefully shed.
Sumit, you may speak now.
Yeah.
Hi, Sumit, welcome.
Yeah, thank you so much for a wonderful webinar that's going to happen right now. So I practice more on the commercial side, and in view of the fact that just a day ago, the government is bringing an ordinance in the insolvency laws, which were a super success up till now for the commercial matters, and they might suspend Section 7, Section 9, and Section 10 of the Insolvency and Bankruptcy Code. As also we find that there is no efficacious remedy as such, because the matters go on pending in the civil courts. And herein I find that the commercial mediation can be very, very instrumental, which is also the theme of this webinar, and which is not so the case much in India, but in other countries. And perhaps formal structured legal framework is the need of the hour, and people become more aware of the commercial mediation happening. So yeah.
That's great to hear. Anyone else who would like to share something, like why mediation, why the interest? How about you, Ayushi? Okay, wait, let me see. Who else is there? Any other familiar faces? Weber is there. Weber, anything about mediation? You've done hosts of mediation in Delhi High Court. I'm unmuting you. Why don't you share something about it? Weber, Kalra. Looks like it doesn't want to speak. Okay. Wait, just having some small technical issues with JC not joining in. He'll be there in another 2 minutes, I believe. Or I guess he's there. Okay, yes. So our speaker is here, Jean-Christophe, and we'll now start. So Jean-Christophe will share about his journey as an in-house counsel, I suppose the importance also of the ICC, the mediation competition, CDRC, the VIAC moves, you know, all those things, and how domain knowledge is interesting. When he was in Delhi in February, we had recorded a small interview with him, and we'll be sharing that link also. That's a more interactive session that we did. Great, so we'll pass it on to Jean-Christophe. The topic is, of course, building a career in commercial mediation. And JC, off to you now. You can start.
Hello. I'm pleased to join you this morning for this webinar on how to build a career in commercial mediation. So Gaurav was so kind to let me know that there were many interested people in your part of the world who also wanted to learn about what you can do with commercial mediation. It's a very powerful discipline. And so I'm pleased to share a couple of moments with you. So my name is Jean-Christophe Barthe-Coularet. I'm a commercial mediator in Switzerland and beyond. I'm going to structure my time with you this morning in the following fashion. I'll show you a couple of slides, and then I would suggest that we do it in a very interactive question-answer format with Gaurav. And should you have any questions, please don't be shy of asking them. This is quality time for all of us, and I hope that you can take something with you. So without further ado, maybe a couple of words about me and my credentials. I'm 44 years old. I'm a binational of Germany and France. I've been living in Switzerland for 10 years now. I'm married. I have 2 children. And my professional background is that of a banker who then became a lawyer, worked in-house, and also accredited as a mediator. I speak various languages, and today I am in charge of a NGO called the World Association of Public-Private Partnership Units and Professionals. I also am co-president of the Swiss Chamber of Commercial Mediation, which represents the interests of 280 commercial mediators in the region. I also launched an initiative called the European Champions Alliance, which helps scale-ups to become champions. You may know that a lot of tech solutions today come from China or from the United States. And due to the fragmentation of the European market, it's necessary to give special attention to scale-ups. I have an in-house experience as a commercial and contract manager when I was working in the industry. And nowadays, I focus on deal mediation as a strategic counsel or as a mediator myself. And I am also part of several boards as a non-executive director. What has shaped me are probably all the experiences that I have been able to collect during my different professional experiences over the last 20 or so years. I've worked in several banks with the German Chamber of Commerce and Industry in Brazil. I've also worked on the philanthropy side with a large industry foundation, the Robert Bosch Stiftung. I have worked with industrial companies, always in a legal, commercial angle. And over the last years, I have been building up alliances, essentially. So I've started an alliance for public-private partnership professionals in order for them to have a network, to be able to incubate new ideas on how to do the new form of public-private partnership that are SDG driven. I hope everybody is familiar with the new Sustainable Development Goal framework of the United Nations 2030 agenda. That's something very important because not just because it meets the environment, social, and governance criteria, the ESG criteria under the CSR framework, corporate social responsibility, but it also helps the projects themselves to de-risk. And this is why it's so important that we look at how can we make public-private partnership, and there are a lot of them around the world, especially in developing countries, to become more successful, because nowadays they're not extremely successful. And obviously, when you're talking about all these different things that have shaped me in the past, for me, there's a couple of things that are recurring. One of them is governance. The other is contract management, dispute avoidance. And together, for me, this is something that belongs together. And this is my experience. And now we're going to go to mediation, and a specific form of mediation. We're going to speak about commercial mediation. And I believe there's commercial value in doing commercial mediation, because the alternative is to go into lengthy and complicated legal proceedings that cost money, because you need to give advance payments in order to place and register your case with a court. A lot of times you also take the risk of not having a specialist who's an expertise in your particular industry. It'll cost money, a lot of money, it'll cost time. And you know that when you give your legal matter to a court or a tribunal, be it a private tribunal like an arbitration tribunal or a public court, you in a way relinquish control over what is being done there. You cannot influence what the decision is, and that's for a good reason, because those who render justice need to be independent. But it's not always to the best interest of the parties. And this is why today I pose this provocative question: can you afford not to do a mediation? I believe you can't. I believe mediation always needs to be part of the different scenarios that you can do when you do dispute resolution systems design. And so I believe there is intrinsic commercial value in doing mediation. I just mentioned that mediation has several advantages. It gives agility, flexibility, and it can be very expedite if the parties agree to solve and to structure their procedure in an efficient way. And so that's a big advantage when you're able to schedule meetings. Mediation also offers the possibility, when both parties can't agree on a mediator, to do it as a co-mediation. Say one party is in India and likes to work with one specific mediator. Say the other party is in, say, Switzerland. There is the possibility to do a co-mediation, which brings several advantages, because you may be able to look at things from a different perspective. You have 4 pairs of eyes looking at the dispute and not just 2. And they can complement each other. Obviously, both parties need to be, I call it omnipartial, not just multipartial, but omnipartial. So depending on the number of parties involved, this is also a big advantage of an arbitration. You can, of a mediation, you can cover different forms of scenarios, and that's a big advantage. Exactly. So the other big advantage is obviously that you maintain confidentiality. If you have worked in a business, you know that it's not a pleasing situation to have to reveal things that didn't go so well in the public space. When you do that in front of a state court, everything needs by law to be transparent and public, and there's a good reason for that. But many disputes that end up in court simply end there because there are emotions involved. And it's good to give that safe space for the parties to be able to discuss these matters with the help of a neutral, not specifically a mediator, but a neutral person that will help facilitate the matter. The big advantage of a mediation, though, is that no matter what is being shared during that mediation session is confidential to all parties and will not be able to be used against the other party in a continued legal proceeding if the parties are not able to settle the matter through a mediated agreement. And that's a big incentive to try a mediation, because you don't lose anything, but you have all the possibilities to do things that are unimaginable to both parties if they go in front of a court. It's not the mandate of the arbitrator or of the judge to address the emotional state of the parties, but the mediator can work with that. And emotions are not something negative per se. Emotions can also positively influence the outcome of a dispute. And so please keep in mind that there's tremendous advantages to go with a mediation. Obviously, when you look at it from a simply return on investment perspective, there's always a bottom line to a business. Is it worthwhile conducting lengthy arbitration procedures that are only worth if you have big contracts involved, because it's a private tribunal? You need to pay for private justice. You need to have qualified lawyers. The briefs, the memoranda that are going to be submitted usually are pretty long. And the arbitrators also need to make a living, so they ask for fees. So we're talking at least about, depending on if you take a sole or a three-party arbitral tribunal, we're talking about several people involved, and that obviously comes at a cost. And the cost will be less with a mediator, because you don't need to drill down to the same degree as with an arbitration procedure. A mediator will actually look at how the parties present the facts, work with their positions, and then try to shift and look for the interest that each side has and what unites them in order to construct something that will allow the parties to do a personal transformation of the conflict towards something that works for the future. And there's another interesting aspect when you compare arbitration and mediation or a state proceeding. Usually the mediation will be the only procedure that allows you to look into the future. Whereas if you've been involved in arbitrations like I have in the past, what parties tend to do is they need to clarify what happened in the past. So you have to appoint a lot of witness. You need to do witness briefings and testimonies, and that takes a lot of energy from current project work, and this is not very wisely used money. So from that side, it's going to drag a lot of energy away from the parties. Another interesting aspect with a mediation and a redhibitorial condition for it to work is that the parties involved at the negotiation table have to have authority to speak on behalf of their companies and to settle the matter. So that can only be somebody with a profit and loss responsibility with a company. I like to call that the license to negotiate, the LTN. It's like James Bond has a license to kill. Well, the person sitting at that negotiation table with the mediator have to have a license to negotiate on behalf of their company because they are best fit to meet the interests that their companies have. It's important to note that it's a self-determined decision-making. The parties don't need to ask for the mediator to settle anything because the mediator only intervenes as the facilitator. The solution comes from the parties themselves. And they are also the ones who control the outcome. So yeah, it's very easy, very straightforward. But the success rate of mediations is pretty amazing because over 80% of all mediated settlements are actually going to hold. And that's a pretty impressive number when you see that it really relies on the autonomy and on the will of the parties to work in an interest-based negotiation towards an outcome that works for them for the future. We'll come to that maybe a little later with more detail, but questions that the mediator can ask the parties will have the ability to frame the dispute at stake. And they bring momentum. Depending on the way that the questions are being framed, you're going to be able to really influence the mediation. To give you a very simple example, say both parties have difficulties to relate to each other, the mediator can put fantasy questions, that's how we call them. Say, you have a magic wand and what will have happened in the future for you to resolve the dispute. That completely changes the way the parties feel and interact with each other. And that is that momentum that is that you can find in a mediated outcome. I like the sentence that Kenneth Cloak frequently repeats: all resistance matches an unmet need. So a lot of time when you're in an adversarial situation and people are saturated with emotions and not able to accept anymore any signal, that's usually a sign when there needs to be a pause to try to change the perspective, to try to take a helicopter view and see, okay, what is happening? Is it me being so drawn into emotions that my emotions are so saturated I cannot think clearly anymore? If that is still to my advantage to react that way, I need to start maybe interacting with somebody who will be able to give me the bigger picture. And that's the role of the mediator, to help the parties to overcome these things and to do the right thing in order for the conflict to not go on and be able to solve that. And yes, with this, let's start the Q&A session, I would say. Gaurav?
Great. Thank you, Jean-Christophe. Okay, so we'll take live questions as well. We have already received a few questions. One of them is, in today's time when people still prefer litigation and going to court, how relevant do you think mediation is?
Can you repeat how valuable you think mediation is?
So someone asked that, people still prefer going to court for litigation.
Yes.
They
Yes.
go to arbitrations. How relevant is mediation then?
Well, as I phrased it at the beginning, can you afford not to try to do a mediation? No matter at what state you are in a legal procedure, there's always the possibility to try to try a mediation, because you're not going to lose anything. You're actually going to maximize the possibilities through a mediation. You can interrupt the legal proceeding at any time, because it's a party autonomy. The parties drive the civil process, and so that's the big advantage of being in control of things. You can decide until the court has ruled. You can still find other solutions.
Okay. That's good. That's good enough for us.
I see somebody is raising hands here. Rusha Durana wants to ask a question.
Perfect. So Rusha, we'll go ahead and unmute you. Please ask your question. I know. Maybe,
Rusha, your question.
He left. He left after that. He raised the hand. Maybe permission to leave. That was he was asking. Okay. So what kind of what type of mediators do we have? What are the different types of mediators? Like we have commercial mediation, family mediation. Is there any other specific type?
Am I still sharing my screen? Just a second.
No, I just closed the screen.
Super. Thank you. There are several different forms of mediators. Like I would call the overarching name for that is a neutral, an ADR neutral, because that can be various kind of things. There are mediators who are specialized in particular disciplines, like family mediators, commercial mediators, peace mediators. Mediating is actually a very old discipline. Mediation has existed for hundreds of years, maybe even thousands of years. We didn't call it mediation at that time, but it's the faculty of being able to essentially proceed with a discovery in which a skillful mediator can allow the parties with a fixed position to coalesce into something that will give them something completely unexpected that can emerge. That's this creative power of innovation that can only be generated through these interesting questions with momentum, and that will allow the parties to find a better solution for the future and completely transform the conflict at hand. And that's something that is common to all those mediators, even though they may be specialized in different areas. There are very similar disciplines also called, like there's cyber mediation coming up today, which is using information and communication tools in order to settle peace negotiations with conflicted parties, multi-partial mediation. So there's plenty of different forms of settling these type of disputes. Exactly, and yeah, very similar disciplines like you know, adjudication, 1+1, conciliations. You can do collaborative law. I hope everybody knows what collaborative law. It's when two lawyers agree to settle or to not proceed in the next step of judicial and the judicial chain of events in case the agreement doesn't come to an end at their level. But that's usually only something that very experienced lawyers are able to do, because obviously they would be cutting their billable hours if they were doing only collaborative.
One thing lawyers definitely hate. Okay, so we have a question from one of the participants, Anil Dubey. He says, how do you think mediation can help in the current COVID-19 times?
Mediation is a big vector nowadays, because we're seeing a surge in court cases. People will not be able to settle that fairly quickly, and the court, as you know, do not give the same agility and flexibility that mediation can provide. So we're telling the mediators to to be ready to also use online means of dispute resolution, like online mediation. It works. You can use the Zoom platform even to do shuttle mediation. That means you're taking breakout rooms.
Yeah, the breakout rooms. Yes.
You listen to one perspective of things and then to the other, and then you bring them together. So these things are technically possible nowadays. Some mediators argue that it's not the same feel, it's not the same smell as if you're with the same people in one room. Obviously, you look to people like this through a computer, and you may not be able to capture all the body language and dynamics that you would see if you had both people in the same room.
Exactly.
But it's working. It's working. And so this. Yeah.
But it's still different, right? Like, you would still I would still prefer mediation in person. How do you think, how effective is online mediation? These days I see, I saw the other day, Gary Weber was doing a lot of mediation. Speaking to Catherine, she's doing a lot of online mediations. You yourself are. How do you think, how effective are they? Especially if you have to take a caucus, how effective can a caucus be?
I believe it's not so much up to how the mediator feels. It's more like, what does it bring the users? Like if the two parties who decide to have an online mediation because they cannot meet in person because of social distancing, it's worthwhile for them to not lose time and try to address the blocking points through an online mediation. The mediator is flexible. I personally don't have a technical preference. I think it's okay to do it online. It works well. And I think it's up to the parties to decide where and how they want to do that. And we have the tools nowadays to do it in a fairly efficient and straightforward fashion.
Okay. So we have one of the participants who would like to ask the question himself. Sarthak, I'm unmuting you. You may ask the question.
So my question to you is that since you said that confidentiality is one of the most important factors in mediation, now when we talk about online mediation, confidentiality is at risk because there are hackers, there is leaking of information. So how do you propose to solve that?
I think it's up to the parties to ensure. Can you cut the microphone, please? Thank you. I think it's up to the parties to ensure that there is no confidentiality breach on their side. I mean, these platforms can be secured with passwords so that they cannot be hacked. Maybe there are more secure platforms than using, say, Zoom or GoToMeeting. It's up to the parties to decide what tool they use to facilitate. Obviously, confidentiality is very important and should be protected to the highest standard. I think it's a matter of integrity, not only for the parties, but also to select the mediator carefully. It should be somebody who's been accredited by an institution, because that way you have the he's embedded under a professional standard, and there can be disciplinary action should there be a breach of principles of confidentiality. For your information, there's a code of conduct for European mediators. I don't know if something equivalent exists in India, but that's a sword that can cut effectively. Thanks for your question.
We have Iram also here. Iram Majid is also in the webinar today. She's attending the webinar. Iram, if you would like to share something on accreditation before I shift to Jean-Christophe about it. There's a repeat question on accreditation, and Iram is with IIAM, so I would love her to also interact. If Iram, you could shed some light on the accreditation courses that are offered in India. Okay, no.
Hello.
Yes, Iram is there.
Good evening. Good evening. Yeah, good evening, everyone. Hi, Jean. How are you?
I'm fine, thank you. Jean-Christophe,
okay.
Please.
Yeah, John, sorry. So I met you many occasions in Paris.
Yes, good.
Yeah. So basically, in India, we need to have. I'm sorry, I'm in very bad shape.
No,
So,
that's
okay. It's the quarantine time. You're allowed to do anything now.
Yeah. So basically, I myself director of Indian Institute of Arbitration and Mediation, and many organizations that offers 40 hours training. So it's good to go for the training program which is offered by many organizations. And after that, there are like in IIM, we are having the QAPs for IMI, that is International Mediation Institute, and where you can upgrade yourself with the IMI QAPs after following that. But I must tell you that you should have willingness to do mediation. Until and unless you are not having that kind of willingness for the mediation, or that kind of passion for the mediation, nobody can, no training can make you a good mediator. And for the commercial and for the family mediation, for first of all you have to go through for the 40 hours training. After that you can upgrade yourself.
Right. So, Jean-Christophe, if you would like to share something on the accreditation for becoming a commercial mediator.
Okay, so I can speak about the Swiss standards. To become a mediator accredited under the standard of the Swiss Chamber of Commercial Mediation, there's a minimum requirement of 120 hours of commercial mediation. That's combined between general knowledge and industry-specific and professional experience in commercial, in the field of commercial. There's various disciplines in commercial mediation. So there's some people who are specialized in workplace mediation, and some people do B2B mediation. And then there are certain aspects and like mediation between board members or these type of disciplines. My specialties, if you're interested in knowing that, are in automotive dispute settlement, like in the automotive industry, where we believe that mediation makes more sense than going for big arbitration, because usually a supplier that gets an arbitration clause, and I negotiated hundreds of these, will be completely overwhelmed and risks to be having to file for insolvency if the arbitration is lost. And I think that's not in the interest of many SMEs that enter these agreements with large groups. Yeah, I hope that answers your question.
Yes. So now we have a question from Webhelp. He says, it's a long question though. He says, how do we initiate mediation process that is a private one and not an institutional one? I suppose the question is because in India, we usually have institutionalized arbitrations and not private, or sorry, institutionalized mediations and not private mediations as such, like people still do not, trust. And he also asks, if the mediation is private, then, what is the legal sanctity of the agreement arrived at? Like, can it be enforced properly or not?
So it's party autonomy. The parties can decide who they select as a mediator. There are hybrid cases where one will go take the rules of an institution, but let it run privately. Some people call it wildcat mediation. Essentially, there's party autonomy. Nobody can oblige you to go to an institution. It may make sense because of quality assurance. Say the mediator doesn't perform as the parties want and they want to have an expedite procedure, then it may be worthwhile to go to a well-known institution like the Swiss Chamber of Arbitration Institutions or the International Chamber of Commerce, which has offices in almost every country.
Right, so the next question is by Ishita. She asks, the root cause of a dispute between companies is because of the interpretation of clauses of a contract. Do you think that mediators are well equipped and well qualified to interpret the contractual clauses and help the parties to arrive at a decision? I suppose this may relate to domain knowledge, like we talked about in the interview.
So I think I had two aspects in your question. One is, does mediator need to be a lawyer to be able to interpret clauses?
Yes.
Clearly,
yes.
No. Clearly, the answer is very straightforward, no. That's the parties who need to have their legal counsels to advise them and give them what their legal possibilities are. the role of the mediator, in a nutshell, is that to help facilitate that interest-based negotiation. It's not about, I'm right, you're wrong, get over it. It's much more about helping the parties to find a common narrative for the future. And that's irrespective of how the legal situation is. That they can do in front of court. That's not the role of the mediator, just so there's not a misunderstanding. And the second aspect is that there may be industry-specific knowledge necessary to the parties when they select the mediator. In German, we say Stallgeruch. So how does it smell if you go to the stables with the horses? Well, they want somebody who comes from that same stable in order to be able to help the parties in a succinct fashion to be able to talk the same language. And so you'll be looking, say, somebody who's worked in IP disputes you'll try to look for a mediator who's expert in that area. Exactly. But knowing that he's only going to be helping the parties to understand what their respective position is in order for them to move to interests and to solve the dispute, but not to do a legal interpretation of things. And actually, there's also a risk at that. If it's the same person who's a lawyer and a mediator who has his legal opinion about how things can run, and say you combine that with an arbitration, like a hybrid procedure like med-arb or arbitration, mediation, arbitration, which becomes more and more popular and which makes a lot of sense because you can simply stop the arbitration. You can interrupt the arbitration, try a mediation for 60 or 90 days. Should it not lead anywhere, you can still revert to arbitration, and you haven't lost anything. You've actually maximized the chances to solve the dispute. So yeah, in a nutshell, that's what I would like to say for that point.
Perfect. So we have the next question by Asim. He asks, with all the economic pressures on the practice, will the growth of mediation cut into his income? That's an interesting question now.
With the growth, I haven't had.
With all the economic pressure on the practice, I suppose this is relating to the pandemic. Will the growth of mediation cut into his income?
If it will generate additional income for mediators?
Yes. I think the question is such.
Possibly. I mean, if people know sufficiently about mediation and go for a mediation, obviously there'll be an increased number of mediation cases, and the fees for the mediators will have to be paid. I think the big advantages for the parties are that they will not lose so much money. I mean, that's the return on investment. Say you invest the money to introduce a procedure in front of a court and you don't know what the outcome will be, or in front of an arbitral tribunal, which is only worthwhile if it costs several millions of equivalent, and the outcome you cannot control. And with a mediation, you can control the outcome because you will be the one taking decisions at the end of the day if you have the license to negotiate, and that's why I believe the real question is, can you afford not to do a mediation? Yeah. Okay, that's the most important thing. That's the thing that you need, no matter in what discipline you will be working as lawyers or you are working today. This is the key question to any negotiation that you will be encountering with suppliers, but also say if you work in public administration, it's the same question. Do you want to be held liable in front of a court and not know what the outcome will be, or do you want to be self-determined and be able to at least try to influence the outcome? And that's a matter of controlling.
Exactly. You're absolutely right. So the next question is pertaining to, I suppose, one of your PPT slides. So Ayushi asks, what are some tips and tricks to keep in mind and apply to ensure a successful mediation? And this is in line with your slide that says diplomacy is the art of making someone else do your bidding, but thinking it's their idea.
Yes. I think what will make a mediation successful is having both parties aligned and clear about what the alternative would be if they didn't continue down the route in mediation. Because the alternative is spending more money, having much less agility and flexibility, and losing a lot of time, energy, and resources into something where they don't know exactly where it'll end up. And let's keep in mind the mandate of an arbitral tribunal or of a court, an ordinary state court, is not to solve the emotional dilemma the parties may have. That's not their mandate. And this is something that comes as an extra for the mediation, and that is very helpful because you'll be able to really change the narrative completely from just looking at a contract that didn't work well into reframing the whole future of the whole relationship. And that's so much more powerful because the parties can agree on something completely independent from the old contract. And that's the beauty of doing commercial mediation.
Yes, so we have another question the participant would like to ask himself. Akshit, on to you. You can ask your question now.
You need to unmute, Akshit.
I did, and lowered. You can go and ask the
Thanks.
question.
So thanks, JC, for the very informative presentation. Just to sort of, I had a couple of follow-up questions on two things that you said. One with regards to the negotiation aspect itself, when you said that, you know, obviously that mediators are only supposed to facilitate the process between counsels when they're interpreting clauses. There are times when I've noticed, both as one of the counsels in a negotiation and as well as like a mediator, that sometimes there is a deadlock within the discussion with regards to the interpretation of a couple of key clauses, let's say, such as indemnity, right? In those cases, what do you recommend that we do as mediators to sort of break the deadlock?
To break the deadlock of an interpretation that is antinomic between both legal counsels.
Yeah.
Well, at the end of the day, it's the parties of the conflict who need to make a decision there, not their legal counsels. And that's about the license to negotiate. Who has the license to negotiate? Who calls the shots? At the end of the day, what will prevail? Is it the ego of one side and being right? At what cost? Can you afford? It's that's brutal. Sometimes you need to make compromises and agree on something that may not be, you know, dans les règles de l'art, like in the state of the art from a legal standpoint, but it will help the parties to come forward to something else. Take the pandemic right now, the COVID-19 situation, which is causing so many contracts to be delayed, so many disruptions. And even if your contract has clauses there that say you can claim for compensation, liquidated damage, you name it, will it really help the parties that are confronted with a disruption of a scale we haven't seen since the Second World War? Or is it better for both sides to have a more reasonable approach and find something where they can both agree for something that works for the future? Let's be clear, the contract did not provide for that. And even if you provide for a force majeure clause or a hardship clause or a step in from a public side in order to ensure that there is social distancing, and say if you're under a concession model, there is only a reduced number of users, well, there'll be huge commercial impacts to that. We're very clear about that. But can we at times really insist, okay, and go by the book? This is the context. Sometimes we need to find solutions, and that's only going to be possible if we move. And it's to the person who has the license to negotiate to move.
Exactly. So the license to negotiate always is very important. We have the next question by Damini. She would like to ask a question. Damini, you're up. Go ahead.
Yeah, hi, sir. Am I audible?
Yes.
Yeah, so the question is, a lot of times we see that during an arbitration process,
Yes.
the parties like even the arbitrator and the parties think that this dispute might be resolved by mediation more quickly, and if there's a possibility for that. And there are provisions in our Arbitration Conciliation Act in India that the arbitrator can be the mediator. And do you think that in such scenarios where the arbitrator takes that hat of mediator and the mediation fails, the parties are not able to settle the matter and they have to jump back to the arbitration process, do you see any ethical issues there? And if yes, how do you see like issues like confidentiality? And if yes, and how do you think that they can be resolved? Or are there any rules regarding to that in your jurisdiction?
So regard to the second question, no, it's up to the parties to decide that. There's no state rules that would prevent you to be mediator and arbitrator. However, I believe that it depends on the situation. Sometimes it may be a big advantage because then there's this contextual knowledge of what has been said in a mediation that can be used if the parties agree so in an arbitration. But I prefer, for the sake of a good outcome, to separate these two issues, because if you say the same mediator who's then going to do the arbitration is going to be the same person, you in a sort jeopardize already your mediation, because you're not fully committed to finding a solid outcome for that. So that would be my reply to that.
Great. So we have Sumit who wants to ask a question. Sumit, you're next. Please ask a question.
If I may, until Sunit is ready, I think there's a big importance also for intercultural awareness in that space. You may have heard of Hofstede, who was a scientist who analyzed the relative distance between one culture and another, and that's super important if you're in an international context, be it in an arbitration or a mediation or any negotiation, because the way that you may schedule something or put the culture aspects on a map with regard to timing will be very different if you agree on a precise start of, say, the webinar here in India. It'll be different than in Switzerland. And so there's all these little things that you need to learn to read in the air that are not said, that are so important for any negotiated context. And so if I can really recommend to you a book that I have loved to read, it's this one, The Culture Map, from a professor at INSEAD in Paris. She's American citizen, married to a Frenchman, and she's had this wonderful approach to really give charts on how emotionally expressive certain parts of the world are, how feedback is given. I think that's extremely valuable and helpful for our discipline, because we're about helping people to overcome and avoid conflict. And so I can only recommend you read that. It's also about leadership and how you work in teams. Everybody will have to work in teams at some point, and they will be multidisciplinary. You will not be always around lawyers. And especially if you're with engineers who have a very, structured fashion of working, it's very important that you are able to relate and refer to these relative distances to a context. Sumit, sorry,
Yes, Sumit, go ahead.
No,
mean to
not
talk
worry.
so long.
Thanks, Jean, for the valuable insights. My question is that if we talk internationally,
Yes.
do we say that mediation could be something which is as equal to, can we equalize it to negotiation? Or if there is anything of international negotiation, are there any structured way or rules for this? Because, so what are basically the different modes of ADR? Arbitration is one, mediation we've talked about. Any other mode and any other rules regarding that?
Let's clarify one thing. A mediation is an interest-based negotiation. Boom, for the start. And then there are plenty of other tools. I mean, we talked about collaborative law briefly. There is conciliation, adjudication, arbitration, mini trial. There's plenty of forms also to combine these different procedures with each other. And it will depend on the party's will of having a formal binding decision, something that is temporarily binding. So, you know, dispute resolution systems design is extremely important when you are in a lawyer drafting clauses on behalf of your clients, or when you're in-house and having to draft the general conditions and terms of an agreement or of a convention or of a contract. It's extremely helpful that you take in mind what are the specific needs for that. Is it tactically more interesting to have a you know, a state court proceeding, or do I want to give the parties flexibilities, especially if it's another private party? They may be well advised to provide for a mediation clause, especially if you're in a context with many suppliers. It doesn't make much sense to draft arbitration clauses in there. I know that from my own experience, when we were drafting clauses, a lot of times we had, you know, ICC arbitration clauses. Even though I was working with an organization, Bombardier has over 30,000 employees worldwide, and we had contracts of all forms, shapes, and sizes. It makes sense if you're in a, you know, if you're at the sales contract to your organization, but if you then procure things in your supply chain from many suppliers, and you need to ensure that the contracts are back to back, meaning that the penalty clauses that you have to pay to your customer if you're late are also being passed over to your suppliers, then these things can be really difficult if you have an arbitration clause. First, because it's not going to be extremely reactive. It's going to take a long time to actually file and have the arbitration tribunal up and running. Then if you look at the average duration of an arbitration, even if it's fast track, you'll rarely have something that will give you an outcome in less than a year. I mean, usually it'll be more like 2 or 3 years, especially if you talk about, you know, big oil, big gas arbitrations. And so I think there's huge value in helping shape corporate contracts with suppliers in that supply chain regularium, like norms, where you simply provide for mediation clauses, and those mediation clauses can be either institutional or ad hoc. Very straightforward, but it's take advantage.
Exactly. Adding on to that, like when I draft at my office, when we draft commercial agreements or construction agreements, we necessarily make a provision for mediation these days, that, you know, for any dispute, you will have to submit, let's say, to the Delhi High Court Mediation Center under the, you know, pre-litigation mediation clauses, because I feel that if people venture onto mediation earlier on, they can still save their business relationships, because once the litigation starts, it actually does give, you know, huge pressure on the business relationships. It's not easy to go back to what was prior litigation. So we have a question. We're almost near the time. We have 1 and 2 questions. We have Patambar, who has been waiting to ask a question. Patambar, go on.
Thank you, Gaurav. So John, my question to you is regarding, since, you know, we're talking about you know, commercial mediation. So my question has basically 2 parts to it. First part is about what is your viewpoint regarding Singapore Convention on Mediation, and my second question is about you know, what are the, you know, what is holding back EU from joining the, like, for ratifying the, or maybe even signing the Singapore Convention, and when do you think can, you know, Switzerland actually take a step ahead and, you know, go ahead and sign it? Because if you are, you know, really concerned about maybe commercial mediation or creating a framework which is international in nature, then I think signing Singapore Convention could be a great step. So just want to hear your views on that. Thank you.
Before Jean-Christophe, you start, this was the last question we discussed even yesterday, and this is a question that comes up every time. And, you know, I'm sure Jean-Christophe will take this up, but Padabar, even as a mediation advocate, even I have my doubts on the Singapore Convention, though it is authored by a person that I know. But you know, it still has a lot of issues. Like with the Singapore Convention, it will, in my opinion, it will actually take the autonomy and the flexibility out of mediation rather than keeping it as flexible as it today? On to you, John. What are your thoughts on it?
So if we look here, I prepared that question because I knew it was coming. If we look at the UNCITRAL, which is the UN organization that looks about on these type of international conventions, this United Nations Convention on International Settlement Agreements resulting from mediation has been signed, so that there are almost 50 states who agreed that they would do that, introduce that as bills. To this date, only in 3 countries has it been ratified. I'll give you the names: Fiji Island, okay, Qatar, and Singapore, and that's it. So the Singapore Convention today would only be applicable if there was one contract party from, say, Fiji and the other from Qatar or Singapore. The scope is not there. And yes, it maybe one day we'll have something that is equivalent to the New York Convention for the enforcement of international arbitration settlements. Would be a big marketing coup, and it would work. My question is a little bit nuanced, because I know that under Article 5 of the Singapore Convention, there's the possibility in cases where the ordre public, so the public legal order of a jurisdiction has been violated, there's the possibility to do a revision. And that in a way weakens, for me, the instrument of party autonomy and mediation. Yes, for a very important reason, obviously, ordre public, which could happen in cases like money laundering, or if there has been corruption or a criminal act committed through that mediated agreement. That would be like a cover-up. And for these cases, I agree that it's not correct, and there should probably be a way to do away with such harmful agreements. But my question is, does it really need an international convention? If I had a mediated agreement with 2 parties, I personally would simply go to a notary public or to a public tribunal and give it the force of something that has been decided, and that way it becomes executable too. And it's nothing else than what the Singapore Convention is doing with an international treaty here. It's positive from a marketing standpoint for international commercial mediation, because many companies are now aware that there are efforts being undertaken to step up in mediation and make it something that is more commonly agreeable as a means of dispute settlement, especially in the international context. That's very positive, I believe. At the same time, I'm not sure if it's going to change much that quickly. The European Union is a little bit reluctant to it, I believe. I mean, I don't speak as a politician, but just as somebody who's observing things. The European Union, not a single state has signed the Singapore Convention, because the European legal order has already these mechanisms of being able to recognize foreign judgments amongst member states, so not with third parties, but obviously there are so many different legal standards that it's not comparable to the legal standards in Europe many times, and so that it would be difficult to do an equivalence recognition. Maybe someday it will come. We see that China has ratified it. We see that India has signed it, not ratified. Sorry, I misspoke. There's many countries who have signed it, but so far the impact is not there because it hasn't been ratified by the parliaments.
Exactly. Thank you. For the last question for the evening today, JC, we have, what are some tips you would give to a fresher into the field, who's entering into the field of mediation? And combined with the question that, do you think that apart from law, like legal subjects, are there any other areas that a person needs to master before venturing into commercial mediation?
I think, well, you don't need to be a lawyer to be a good mediator, to make that very clear. And when we met at the ICC mediation competition, we saw extremely powerful and efficient teams with a lot of talent and creative solutions when they came from multidisciplinary faculties. And so I would encourage you to also look at people who share the same interest for an interest-based negotiation that you do, but look at how through their education, the perspective may be enriched and more compelling also for you because it comes back to you. I think it's important to hone your mediation skills, and no matter in what role you will be working in your career, because it's going to help you to frame things from a communication standpoint in a non-hostile way. It'll help you to also sometimes take a distance, to decelerate things when they become too quick, to reframe aspects, and looking at it from different perspectives and being able to ask these very powerful transformative questions is going to put you in a position where it'll be easier for you, even if you don't work as a mediator in mediations. It'll help you in arbitrations, it'll help you for any contract negotiation, it'll help you as a professional to become better. And I like to say the soft skills of today are the hard skills of the future. And the earlier you start in your career to polish these skills, the further you will be able to master that discipline and become an excellent professional. And it's something I can really encourage everyone to go down that route. I myself discovered mediation when I had complicated distributive negotiations, and I saw that with classical commercial posturing, I wasn't able to move the thing anymore away. We advanced millimeter by millimeter, and only the possibility of really having a license to negotiate with somebody who can speak on behalf of the company and look at what are the deeper interests of the party, were we able to move this to the next step. And this is something that convinced me to move from arbitration to mediation, and here I am today promoting the use of commercial mediation, and I hope that many of you will influence that in the future, and it was a big pleasure to share that time with you today.
Great. Thank you, Jean-Christophe, for joining us today. Quickly, people, we just have, and yes, to one of the cultural things that you said, just coming on, back to that, I do believe that cultural interaction, especially for mediation, is really important, because commercial mediation can easily cross borders in solving disputes rather than the other forms of, dispute resolution, be it litigation and arbitration, because they're still stagnant to a large extent. You have a lot of procedures that you need to follow. In a commercial mediation, the client can be in Brazil, the mediator can be in Geneva, the other party can be in India, and we can still solve the dispute over a normal phone call or a Zoom call or any other form of web call. So that's very interesting. And the aspect of that you need to understand the cultural differences is very important when you especially do cross-border negotiations. From my personal experience, from very few cases I've done for cross-border deals, is that if you do not understand that how under pressure the other person is going to react, there is a heavy chance that you would eventually end up irritating them and you will spoil your deal. So, you need to understand where the person is coming from. And on that note, we have Pascal, who is also Jean-Christophe's dear friend, joining us on Tuesday on dealing with high conflict individuals in negotiations, using scientific method, and that is worth listening to. Thank you everyone for joining us. Thank you, Jean-Christophe. Have a wonderful evening ahead. Yes, a user's guide to the unconscious mind. Great. Thank you, everyone. We'll see you on Tuesday now. Bye-bye.
Bye-bye. It was a pleasure.